cases and they appear on the calendar. I'm assuming that Mr. Wheeler has explained the operation of the clock so that we don't need to go over that. Immediately after the first case, we're going to take a brief recess for coffee, and you're welcome to join us in the Lawyers Lounge, which is immediately out there for coffee following the first case. Mr. Floyd?
Thank you. May it please the court. I'm J. Patrick Floyd on behalf of the petitioners Joe and Mary Bush, and we would request 5 minutes for rebuttal, please. We here ask the court find that the lower court failed to provide the essential requirements of law resulting in harm to the petitioners and denied procedural due process in granting of the motion to dismiss and the dismissal of the amended petition for writ of certiorari that was filed in the lower court, and to ask the court to exercise certiorari jurisdiction, grant relief, and quash the order of the lower court that dismissed the amended petition below.
Mr. Floyd, you're of course aware of our limited scope of review on second-tier certiorari, and where within that limited scope of review do we fit here?
You fit here right within the substantive due process and the departure from the essential requirements of law, in that that is what was denied by the lower court in granting the motion to dismiss. Right within that, as evidenced also by the Cook case that's cited in the briefs.
When, counsel, did the comp plan issue arise?
The comp plan issue, it is not an issue. It actually was embedded into a quote final order in May the 21st of 2010, after the time that the city commission had voted on it, and the actual final order never was incorporated, never was voted on, never was passed, the findings were never discussed, never proposed or announced or allowed to be challenged by the city commission.
So the issue of the compliance with the comp plan was at no point mentioned until it appeared in the order?
That is correct. In fact, Your Honor, it was not the first mention of any type of challenge by the city of Mexico Beach. Was clearly, and it was clearly stated and repeated numerous times since 2006, that their challenge was that this was in violation of the land development regulations, specifically the density and the impervious conditions that were the only ones that were specified in the land development regulations. And consequently, that's what was done here. The comprehensive plan was put into force and effect by the enactment of these standards by Mexico Beach. This was the way that they were going to objectively enforce and regulate their particular neighborhood as set out in there, which gave a due process right and dependency by the people on that which was written. Certainly, that's one of the problems. But let's go back to where we are with the motion to dismiss, because it makes it very simple here. This was a dismissal of the amended petition for writ of certiorari in the lower court that disallowed us to even get to the point of granting, of considering on the merits the petition for writ of certiorari. That itself was a denial of due process and the departure from the essential requirements of law.
Well, if I understand your argument correctly, that the real denial of due process occurred in the administrative tribunal before the circuit court. In other words, if just follow this for a second, but if you had notice that this could be denied on the basis of consistency with the land use plan, and if you had an opportunity to be heard on that point, and if the decision had been made on that point after a full and fair hearing, then what would be wrong with the circuit court dismissing it on the ground that, you know, you didn't file a declaratory judgment action, and really it's whether, you know, all your other issues are really moot? I mean, you know.
With your particular setting, then there would have been probably a filing of a separate declaratory decree.
And if you'd failed to do that under all those facts, and I realize those are not the facts of this case, or at least according to your view of it, but if those were the facts, and if the judge had done that, just to get it clear, there would be nothing wrong with that, right? I mean, in other words, you'd have no case at that point, because you'd have no way to know, there would be, none of these other issues would matter.
And let me...
and that's where the circuit judge was going, I think, right?
I don't think so, Judge, because I think once this was reviewed on the merits, of course, as this is different from what your presumption is,
right,
then they would have been, there's adequate, and not only adequate, but surplus demonstration that this particular case is littered with denials of due process and departure from the requirements of law. But presuming yours, if they had in the process that it had been raised and it had been, there was evidence, sworn evidence produced to document it, and it was an issue that we could attack, and we had litigated it in the procedure before the City of Mexico Beach, then there would be a basis at that particular time for us to say, okay, we're going to file a separate, and although I'm still dazed by that, to have to file a separate complaint for declaratory and injunctive relief at the same time you file the petition for certiorari review. The thing that separates this particular case from that is, number one, we're just dealing with the dismissal. Not even the Cook case was there a dismissal. In the Cook case, there was actually reached on the merits, and there was the court said there was denial of due process for purposes of the lower court ruling, and quash that particular order, sending it back to circuit court. That's what should be done. But here is a motion to dismiss, and it was presumed by the court that there is, in fact, the denial of due process, the departure from requirements of law that is harmful to the petitioners, Joe and Mary Bush, in this case. And given that presumption, then she said, as urged by the City of Mexico Beach, that there was no type of action she could take that would give effect. But that's wrong, because this particular language, and as we had referenced in the brief, this language was embedded in the order.
Wasn't it in the staff report?
Judge,
I'm not clear. I'm not, because I don't know these facts of the case as well as you do, but did your client receive this? Was it in the staff report, and did your client receive the staff report like before the hearing?
No, sir. Not only we never received it, we never heard of it. It was never mentioned to us. It was never produced until the response to this court that was attached to their brief. And that's the reason I presume that the court struck that particular staff report. It's a self-serving report, and it was produced by the same person, the city administrator from Mexico Beach, who, when we were at a hearing, we asked him, why didn't you give us opportunity to question these reasons and to set these? And he said, I'm not required to give you any answers from City of Mexico Beach. And of course, the LDRs are replete with requirements that the city administrator is the one that was required to issue this within an hour or two. I think you see from it said an hour or two with the LDRs, and then it said later on in a different version, as soon as possible. If it was in compliance with the LDRs, he was to issue the development order. And there's never been any dispute, but that the LDRs that were applicable at that time were only two that put into effect the goals of the comprehensive plan. Those LDRs were the density that had to be 7,260 square feet. This was 7,900 each one, and had to meet the impervious requirements. The fact that it met those particular requirements, Your Honors, is the reason that Mexico Beach started in 2008 along the trail of trying to pass an amendment to the comprehensive plan in order to incorporate this section, this ordinance 381, so that it would have properly enacted and a part of the comprehensive plan to bring those before the City Commission and the Planning and Zoning Board. It was not there before that. The second part of this proposed amendment to the LDR, which was 3.07.00, that they started the process of doing, was to incorporate more standards, more objective standards in the neighborhood consistency.
But that provision was not in effect at the time your client filed their request to approve the split, right?
That is correct. Not in effect at the time it was actually split in 2005, not in effect in 2009, not in effect.
That was adopted in April 13, 2010, is that
2010, after the time, at the meeting, after the time the quasi-judicial hearing had already taken place, which was the only quasi-judicial hearing that had taken place. And that had been urged and actually stated, as stated in the record by Mexico Beach, that it was not going to affect the actual, the applications by these people. Those are the only two. From here on, it's already eliminated because of the newer standards. But even the newer standards that are set out, if Mexico Beach is allowed to go by and look at the comprehensive plan and say, whatever we think is going to be what we set out and we make people comply with, as opposed to what the objective standards are, then we're in a continual denial of due process. This order should be, on the motion to dismiss, should be quashed and sent back to the lower court to address it on the merits, the amended petition for certiorari.
Thank you, Counsel. You'll have about 4 minutes and 15 seconds.
Thank you.
Good morning. May it please the Court. My name is David Theriak. I represent Mexico Beach. I'd like to begin by pointing out the standard of review, which was mentioned, I believe, as one of the first questions. And this is second-tier cert. And the petitioners have not alleged that there has been an inherent illegality, that there's been an abuse of judicial power, or that there's been an act of judicial tyranny that rises to the degree of a gross miscarriage of justice. Without those predicate, this court does not have the ability to quash local government's decision. And the Supreme Court recently, in the Custer case, reaffirmed the narrowness of second-tier cert. I would also like to point out that what took place regarding the 2005 lot split, what took place regarding the processing of this application, I respectfully submit is not before you today. We're here today on whether the circuit court properly dismissed the petition on the grounds that the petitioners had failed to file two types of lawsuits. In Florida, when a land use decision is challenged, the challenger, if it is a denial, has to ring the bell on two prongs. They have to ring the bell that the city was wrong when the city held that the application violated the Land Development Code, and if the city also stated that the application violated the comprehensive plan, the applicant must ring the bell on both. That's different than Cook, which the petitioners raised in their petition and also raised during their argument. In Cook, that was a challenger to an approval. A challenger only has to ring the bell on one. The challenger has the right to say, well, it did not meet the Land Development Code or it did not meet the comp plan, and if they ring the bell on either one of those, then the decision is overturned. But again, that's different than what we have here, where you had a denial. And the final order, which the Supreme Court has stated that the local government is not obligated to make any findings of fact during its hearing.
But how was the petitioner provided fundamental due process here?
They had a hearing.
And what was the nature of that hearing? That was the hearing on April 13?
Yes, and I would also submit, Your Honor, that the questions about what occurred at the hearing are also not properly before you, because you don't have an official transcript. The petitioner's secretary has typed what they believe to be a verbatim transcript, and we respectfully submit that that is not an appropriate transcript for this court to be reviewing what occurred. Setting that aside, the hearing, even if you're using the petitioner's unofficial transcript, started off with the city manager indicating that they had hired land use counsel and that the city desired additional time. They asked for this hearing to be tabled. And as a courtesy to Mr. Floyd, they allowed Mr. Floyd to present whatever argument he wanted to present at that day. At the conclusion, and again, this is in the unofficial transcript, I was not present that day, but at the conclusion of that hearing, they tabled it to a date in the future for the city council to take further action. That action occurred after an executive session on May 11th. The reason there was an executive session, that's a private litigation session, is because Mr. Floyd, on behalf of his clients, had another lawsuit pending for the writ of mandamus. And the writ of mandamus was to order the city to hold the quasi-judicial hearing, or in the alternative, to declare that the 2005 lot split was valid. So the city council held an executive session after they retained me to evaluate that, and then they went into a formal session and voted to deny the application for lot split. The final order, until recently, a local government wasn't even required to do a written final order with any specificity. They could just say denied. And the legislature amended, make sure I get my cite here, 166.033. And the legislature stated that after a local government votes to decline, then a notice must go out stating the grounds. And that's what the city of Mexico Beach did here. They cited the grounds, and we disagree with the petitioners. It's the city's position that the newly adopted standard in the land development regs, the 307 that dealt with the 10%.
Is there no point in the process, though, where these landowners would have had the right to argue this consistency issue before the city?
It's not on the record issue, though, Judge Padovano. The consistency issue is de novo in circuit court under 163.3215. It's the exclusive remedy. So even if there was no evidence in the record to address a particular comprehensive plan policy, I respectfully submit, because the review is de novo, because the Supreme Court has held that findings of fact are not required by a local government.
So there is no right to a hearing before the city?
Oh, there's a right to a hearing.
All right. When did Mr. Floyd's clients first get notice that this was an issue that could possibly affect their application?
I do not know when they first.
Because it doesn't seem to me they ever had notice of that, according to Mr. Floyd's argument.
I do not know, but the burden is on the applicant to demonstrate compliance with all provisions of the comprehensive plan. That's the initial burdens on the applicant. The burden's not on the city to start off a hearing and say, applicant, we have a concern with policy 1.4.2. The applicant has the initial burden to demonstrate compliance.
Well, counsel, at the time the petitioners requested the lot split, was there a requirement that that lot split comply with the comprehensive plan?
Yes.
So the LDR in effect at that time?
There's been, I believe, petitioner counsel correctly stated the relationship of the comp plan and the land development code. The comprehensive plan policies that we're dealing with were adopted in 2007, Your Honor. And under Florida law, every application must comply with both the comprehensive plan and the land development code. And the policies that we were dealing with under the 2007, and this is in the record, the comprehensive plan, it defines development as the dividing of land into two or more parcels. That's the definition of development on page 7. And there were two policies in the comprehensive plan. Policy 1.23, the city shall use this plan and its land development regulations to promote compatibility of adjacent land uses. And policy 1.4.1, the city shall restrict proposed development which is inconsistent with the character of the community. Both of those were in place. What the petitioners argue was not in place was the land development code change that had been pending for a couple years, which was the new language in the subdivision regulations that if you split a lot, I believe more than 10% of the average lot size, that you're not allowed to do that as well. The city submits that under the pending ordinance doctrine, had we gotten to the merits on this at the circuit court level, that under Smith versus City of Clearwater, that the red flag doctrine was pending, and that this ordinance had been pending for a couple years. They were on notice. The record would reflect that Mr. Floyd's client attended those hearings, and they had full knowledge. And the decision to deny was after the city adopted 307 with the new language. So we respectfully submit that the new language in 307 was also applicable.
But it was a decision based on an issue that was not in play by the petition or any response or by the ground for the initial denial. In other words, it looks, and correct me if I'm wrong here, because I'm trying to get a handle on what happened, but it looks to me like Mr. Floyd, the application was denied on a reason not really initially not relating to this consistency thing. Mr. Floyd contested that based on land development regulation issues which could have traveled up the certiorari chain properly. They could have been quasi-judicial action, and then all of a sudden out of left field comes a denial based on some other reason that requires court action. And so if he had no notice that this was coming from left field, again, you tell me if I'm wrong, because I probably am, I don't know, but I'm just telling you what my impression of the case is, then why wouldn't this be a denial of due process for his clients? It seems like just not the way we do things in American courts. I mean, you just don't come up here with a reason that you give them at the last minute, which requires some other kind of litigation.
Judge Padovano, I would disagree with the contention that somehow it came out of left field. The record reflects in the petitioner's appendix that neighbors showed up at the Planning Commission to complain that the lot split would be different in the character of their neighborhood, and that they bought into that neighborhood expecting a certain lot size. So that was in the Planning and Zoning Board meeting back in 2009. The Planning and Zoning Board recommended denial based upon the evidence that they heard during that hearing. The City Council, so at that point, we're looking almost 6 months, 7 months prior to the May 11th decision. The issue of character and compatibility with the adjacent neighbors had already been raised by the neighbors. Mr. Bush was clearly on notice, his attorney was clearly on notice, and they have the burden of demonstrating that the comprehensive plan policies that were in effect, this wasn't something that the city adopted afterwards. This is something that was in effect. They have the obligation to demonstrate compliance, and they failed to do so. And the issue wasn't raised in certiorari for the first time. There's a final order under state law that states here's the grounds why we denied your application. And at that juncture, had the petitioners disagreed with the comprehensive plan policies that were cited, then their exclusive remedy was to file a de novo proceeding under 163-3215. And that de novo proceeding, you start from scratch. There is no record that comes up from the City Council. You're not limited to reviewing the record to see if there's competent substantial evidence. It's a de novo proceeding, and the petitioner has the obligation to demonstrate compliance with those two policies. And that was something that the legislature recently amended to allow applicants who are denied that ability. At one point, an applicant was limited to serve, but approximately 2002, 2003, the legislature changed that so that even an applicant has the right to a de novo proceeding.
Well, let me ask you a question. If the city of Mexico Beach just said to a landowner, we're not going to approve your application for a lot split. We're not going to give you a hearing. We're not going to hear your argument. We're not going to give you notice of when we're going to act. We're not even going to hold a public meeting. We're just going to go in the back room, sign an order saying application denied, not consistent with the land use plan. We'll put it in the mail to you. Are you saying that this would be okay because you have a right to a de novo hearing in court?
No, sir, I'm not.
Okay, so what happened before the city that, in your view, represents due process for these landowners?
A hearing was noticed, an opportunity was heard. Mr. Floyd argued. There was a hearing before the Planning and Zoning Board where neighbors spoke. The Planning and Zoning Board's recommendation of denial was forwarded to the City Commission.
Did they have some indication before the hearing that this issue was in play?
I would say, based upon the neighbor's testimony at the Planning and Zoning Board, Your Honor, that yes, they had notice, and in any event, the laws clearly have constructive notice that they're obligated to demonstrate compliance with the comprehensive plan. They failed to do that. And the hypothetical that you provided, which we don't have.
I understand that. I understand that your case is a lot better than the hypothetical I propose. I'm just trying to get to the bottom of the issue.
But even under that scenario, because there's 3 prongs on a cert case. You're looking at whether a denial based upon a land development code or an approval based upon a land development code was supported by competent substantial evidence. You're also looking at whether the denial or the approval based upon the land development code departed from the essential requirements of the law. Your third prong is the due process. That's your standard three-part test as a circuit court judge looking at certiorari. And to the extent due process is raised, we respectfully submit that you still, an individual who's challenging the decision still has to file both lawsuits. They still have to file the cert. They still have to file the 163-3215 to preserve that issue. They can move to consolidate the two proceedings. They can move to abate one and see what happens with the other. But they simply failed to preserve that issue. And by failing to preserve that issue, we submit that Judge Costello properly dismissed the petition.
So all of the cases, and there's more than Cook, that say that you have a right to certiorari relief, all of the, and no obligation to file the declaratory judgment action, all of those cases, or none of those cases involve a petitioner initially seeking the land use change.
I'm not sure what all the cases are, but all the cases we've looked at, Your Honor, is if there was just a certiorari petition filed, and if it was by a third party, the third party only had to win on one, whether it was a cert or the 3215. If it was a developer, we don't know on those certiorari cases if they filed a companion 3215. But under the law, it's clear that a 3215 is the exclusive remedy to raise the comprehensive plan issue.
Thank you, Counsel.
Thank you very much.
Counsel, their argument of the respondent concerning Cook limits Cook to actions by third parties. Can you talk about that for a minute?
Yes, Your Honor. That particular case, obviously one that the respondent does not really want us to get to the details of, actually is a broader application of the fact that if your focus, if your issue is on something other than the comprehensive plan, as it was in this case, as it was in the Cook case, then that particular matter, by constitutional right under Article 5, you have the right to proceed to the circuit court and through the process of certiorari relief. It's a fundamental due process right to be able to pursue that. The Cook case actually dealt with zoning, which is a part of the LDR to put into place, just like in this case, the comprehensive plan requirements of what they were going to require in that area, and they required 100 by 150 foot lots. The replat was going to change that and not comply with 100 and 150 foot lots, and therefore that was what was attacked. That was what Mr. Theriac attacked, and in this particular case, the same point here is the LDR. It was just two simple requirements. If the city of Mexico Beach is allowed, and I'm going to get, this is off the point really because we're dealing with the motion to dismiss, but I'm going to deal with it quickly. If the city of Mexico Beach is allowed, even now with their new ones, to say, well, here's what we now say were the requirements implemented, put in force, in effect by the LDRs of the goals of the comprehensive plan, but when you go before them, there is some other basis that they may disagree with that you're not on the notice of, that they're going to hold you to the standard of, that's a denial of due process.
As I understand, Mr. Theriac, the law applicable at the time the request was filed required compliance with the comp plan, and you were on notice of that. So you had the burden, your clients had the burden of showing that. So that requirement was in effect. Why is he wrong?
He's wrong because of this. Number one, we did comply with everything. That was not an issue of compliance with the comp plan. By meeting the only objective and written requirements of the Mexico Beach regarding this division in the LDR, which incorporated logically those 1.23 and 1.31, the LDR is put in force in effect. By meeting those, we met every requirement of the land development of the comprehensive plan, and it goes without saying, here's what it says in the land development regulations. They even incorporated the logic of what we're talking about into a statement in the LDR itself. In 7.01.01b, I quote, "A development shall be considered consistent with the adopted comprehensive plan if the development conforms to the provisions set forth in the applicable City of Mexico Beach LDR." We went exactly by that, my clients did. When they divided in 2005, same thing in effect in 2009. Those particular requirements, when we went before the Planning and Zoning Board, the only issue was the density and was the impervious requirements. That was the only thing. Some people out there were talking about something else beyond that, but that was not in effect. And in fact, those comments were used to try to pass this, to move forward and pass something different. That's obvious that it was not in effect. So the 166, this particular part in 166 that he has talked about the giving the reasons, 166.033.
Counsel, your time has expired. If you can go ahead and just wrap up.
Okay, thank you, Your Honor. That particular one deals with, you have to put the reasons down that you're going to do it. Reasons that were asserted in the proceeding itself that the petitioners had notice of so that they could argue it. Not that it was never mentioned, never ruled upon, and never acted upon by the city commission, as in this case, and then you later embed it into the order in an attempt to ambush these people at a later time. That's simply not due process and
Thank you,
motion.
counsel.
Thank you, Judge.
We will stand in recess, and I stand corrected. The lounge is on the third floor. I didn't know where I was.